Get a grip and get a chip. Won't even trip. Though my cup was running over, I took only a sip. Stay hippin', then I'm hopping, I'm dropping. It won't be flopping, no shock. That whatever I'm selling, you will be copping. He was the strongest, though he was the one that cried. And he chose to kill his brother because he was from that side. And why? He chose this son because this one had pride. And instead of the narrow road, he chose the one that's wide. Sometimes the one that won was the one that tried. And the one who pulled the gun was the one that died. Looking good, a good look is the one that's fine. If I had to pick, fly would be the one that's mine. G-O-D, in the place to be. Attend D, Hard Knocks University. And since kindergarten, they've been hiding the knowledge. Homeboy is self-taught, never went to college. I'm brown skinned, I'm from Pelon. Rainy alarm, then I remain cool and calm. Reading Psalm, fire like napalm bomb.
As we proceed to give you what you need, we are in the information age on Do You Know Your Value page. It's the content creator with force like Darth Vader, back on the track with the facts and all that. One path is the way that I'm taking, getting closer to God in a tight situation. And this morning, we come into you this morning, and we're going to continue going over the Annotated Glossary from Cracking the Code 3rd edition, starting where we left off at the letter M. And so, without further ado, we will start now. Maternity Act of 1921. See note. Note, 1921, the Federal Maternity Act created birth registration, or what we now know as the birth certificate, is what it was known as the Maternity Act, and was sold to the American people as a law to improve maternal and infant mortality, for protecting the health of mothers and infants, and for other purposes. One of those other purposes provided for the establishment of a federal bureau designed to cooperate with state agencies in the overseeing of its operations and expenditures. The Maternity Act was eventually repealed, but parts of it have been found in other legislative acts. Maxims of commerce. See note, commerce. Note, commerce is an antecedent to and more fundamental to society than courts or legal systems, and exists and functions without respect to courts or law systems, but not vice versa. Commercial law, the non-statutory variety, as presented below in Maxims 1 through 10, is the economic extension of natural law into man's social world, and is universal in nature. The foundational, invariant, necessary, and sufficient principles or maxims of commerce are: number one, a workman is worthy of his hire. And these maxims can actually be found in the Bible in certain chapters. Like, for instance, in number one, it says in Exodus 20:15, and the next one will be Leviticus 19:13. The next one will be Matthew 10:10. The next one will be Luke 10:7, and 2 Timothy 2:6. And the legal maxim is, it is against equity for free men not to have the free disposal of their own property. Number two, all are equal under the law. God's law, moral law, and natural law. Once again, these can be found inside the Bible. And the legal maxim is, no one is above the law. Commerce by the law of nations ought to be common and not to be converted into a monopoly and the private gain of a few. In commerce, truth is sovereign. The legal maxim, to lie is to go against the mind. Oriental proverb, of all that is good, sublimity is supreme. Number four, truth is expressed by means of an affidavit. Number five, an unrebutted affidavit stands as truth in commerce. The legal maxim is, he who does not deny admits. Number six, an unrebutted affidavit becomes the judgment in commerce. Any proceeding in a court, tribunal, or arbitration forum consists of a contest or duel of commercial affidavits, wherein the points remaining unrebutted in the end stand as the truth in the matters to which the judgment of the law is applied. Number seven, a matter must be expressed to be resolved. Legal maxim, he who fails to assert his rights has none. Number eight, he who leaves the field of battle first loses by default. And the legal maxim is, he who does not repeal a wrong when he can occasions it. Number nine, sacrifice is the measure of credibility. One who is not damaged, put at risk, or willing to swear an oath on his commercial liability for the truth of his statements and legitimacy of his actions, has no basis to assert claims or charges, and forfeits all credibility and right to claim authority. The legal maxim is he who bears the burden or also to derive the benefit. Number 10, a lien or claim can be satisfied only through rebuttal by counter affidavit, point for point, resolution by jury, or payment. And the legal maxim is if the plaintiff does not prove his case, the defendant is absolved. Because truth is sovereign in commerce and everyone is responsible for propagating the truth in all speaking, writing, and acting, all commercial processes function via affidavit certified and sworn on each affiant's commercial liability as true, correct, and complete, attesting under oath regarding the validity, relevance, and veracity of all matters stated and likewise demanded, usually in written manner such as on an IRS form 1040, 8300, etc., voter registration application, driver's license application, notary form for document certification, application for a Treasury Direct account, and on nearly every document that those who run the system desire anyone to sign in a commercially binding matter. Signature is required under penalty of perjury, true, correct, and complete. In a court setting, however, testimony, oral commercial affidavit, is stated in the judicial equivalent by being sworn to be the truth, the whole truth, and nothing but the truth, so help me God, as well as the need for asserting all matters under solemn oath of personal, commercial, financial, and legal liability. For the validity of each and every statement, participant must provide material evidence, in other words, ledgering, bookkeeping, substantiating that each fact of entry is true, valid, relevant, and verified. Without said acceptance of liability and facts provided to support one's assertions, no credibility is established. Inasmuch as commerce existed before and can continue to exist, irrespective of courts and legal systems, but not vice versa. Commerce is a more fundamental aspect of life than courts and legal systems. Medium of exchange, a substance used to transfer energy from one source to another. American Heritage Dictionary. Mission, a definite task assigned to an individual or unit of the armed forces. See note. Note, apparently Department of the Treasury, IRS, BATF, SEC, etc., and other quasi-governmental and governmental agencies are de facto military units because they each operate off a prescribed mission. Mixed war is carried on between a nation on one side and private individuals on the other. See note, mixed war and appendix, compare dualocracy. Note, mixed war occurs whenever the government of a nation is an enemy of and at war against its own people. The most insidious and perfidious type of mixed war exists when the government acts against the people under guise of protecting the people's rights and upholding the nation's most cherished values and ideals. In such case, government officials are wolves in sheep's clothing, occupying positions of prestige and power with the support of the people while treasonously betraying that trust. This is an ideal confidence game whereby arch charlatan criminals can engage in piracy on an ongoing basis under color of law and be tolerated or even treated as heroes by their victims. For a more comprehensive treatment of this subject, see article in the appendix entitled Mixed War. Money. Money means a medium of exchange authorized or adopted by government. UCC 120124. See note. Note, before the 1933 bankruptcy of the U.S. government, money consisted of gold and silver specie, as well as their equivalent in certificate form. Gold, which is portable land substance, is the money of sovereigns. Fiat money, in other words, money by decree, monopoly money, is the money of artificial persons called banks, corporations, governments, trusts, and individuals. See individual, etc. Monopoly. Trademark, a board game in which a player attempts to gain a monopoly of real estate by advancing around the board and purchasing property, acquiring capital by collecting rent from other players whose pieces land on his property. Webster's C note, Federal Reserve notes. Note, first copyrighted in 1935 by Parker Brothers. Logo includes the caricature of an English banker replete with top hat, tails, and cane. Another allegorical clue from the powers that be as to what is actually going on. Monopolization of all ownership of real estate, land, and wealth. The objective in the game of Monopoly is to drive into bankruptcy all other players. An arrangement otherwise known as tontine. An arrangement otherwise known as a tontine wagering scheme. If you examine the nature of economics in America today, you will see that all land is owned by the state. See Senate Document 43, 73rd Congress, First Session, and everyone is competing for the same fixed amount of monopoly money called Federal Reserve Notes, or FRNs, and attempted to stay above water and avoid bankruptcy. This is by definition a de facto state of war between participants. In both the board game and the game of life, the only way to stay in the game of Monopoly and avoid bankruptcy is to obtain more Monopoly money from other players. The only way to stay in the game of life and avoid bankruptcy is to somehow obtain more Federal Reserve notes, acquire more liability, debt instruments, debt called money from those around you. Tontine, a financial arrangement in which a group of participants share in the arrangement's advantages until all but one has died or defaulted, at which time the whole goes to that survivor. Monster, a human being by birth, but in some part resembling a lower animal. A monster hath no inheritable blood and cannot be heir to any land. It cannot be heir to any land. That's from Ballantyne's Law Dictionary, 1930. A prodigious birth, a prodigious birth, a human birth or offspring not having the shape of mankind, which cannot be heir to any land, albeit it be brought forth in marriage. Black's first. See note. Note, under human being, Ballantyne says only see monster. Neither of the above major law dictionaries defines human being, only monster. Mortgage. Mortgage means a consensual interest in real property, including fixtures, which secures payment or performance of an obligation. UCC 9102A55. See note. Note, mortgage, another gift of Norman French attorneys, comes from the French mort d'eage. Mort dead. Gage, pledge, dead pledge. In other words, killing of the pledge through payment. Name. Names are divided into Christian names as Benjamin and surnames as Franklin. No man can have more than one Christian name, though two or more names, usually kept separate, as John and Peter, may undoubtedly be compounded so as to form in contemplation of law, but one. A letter put between the Christian and surname as an abbreviation of a part of the Christian name, as John B. Peterson, is no part of either. Bouvier's 6. Natural law. Law which so necessarily agrees with the nature and state of man, that without observing its maxims, the peace and happiness of society can never be preserved. Knowledge of natural laws may be attained merely by the light of reason, from the facts of their essential agreeableness with the constitution of human nature. Natural law exists regardless of whether it is enacted as positive law, although there may be instances where natural law cannot be judicially enforced. Barron's 3rd. Natural person, a human being, as opposed to artificial or fictitious persons, such as corporations. The phrase natural person does not include corporate entities, but the phrase person without qualification may or may not include artificial persons, depending on the context. Thus, the phrase no person in the 14th Amendment's Equal Protection Clause has been held to include natural and artificial persons. But the same phrase no person in the 5th Amendment's Privilege Against Self-Incrimination Clause has been held to include only natural persons and not corporations, since the privilege is personal and may not be asserted by an artificial person. Barron's 3rd. See note. No, this is how the IRS justifies insisting that flesh and blood men and women testify against themselves. People answer up when the name of their fictitious trade name is called, and the IRS enforces its commercial agenda against people by treating them like their trade name. The above definition is enlightening, but it is taken from a law dictionary. Please realize that, in the scheme of life, it is just as impossible for a person to be natural as it is for a man to be artificial. Natural, nature and cause. See below. Nature, a fundamental quality that distinguishes one thing from another, the essence of something. Black's 7th. See note. Cause, that which produces an effect, whatever moves, impels, or leads. The origin or foundation of a thing as a pursuit or action, a ground of action. Black's 1st. See note. Note, the right of an accused party to be informed of the nature and cause of any criminal accusation is secured by the 6th Amendment of the Constitution. This term concerns the two absolutely essential elements necessary to establish claims, charges, and demands as commercially and lawfully valid, both criminal and civil, and without which any matter affirmed is devoid of credibility and legal force and effect. Nature. The nature of an accusation is the proof. In other words, ledgering, bookkeeping, set forth with a one-to-one accounting of goods or services provided or offenses committed with corresponding monetary values, with each and every matter established by affidavit sworn on the commercial liability of the executing party. Cause. Only individual free will men and women can act. Nations, governments, and agencies cannot act. At the origin of each and every allegation and act is the man/woman who is the cause thereof. The cause of an accusation is therefore the particular man or woman who can initiate allegations, claims, and charges, the credibility of which is established by the degree of commercial liability the alleging party stakes on what he or she asserts. By initiating something that can cause another harm, loss, the alleging party simultaneously agrees to be held personally, legally, and commercially accountable and liable for the accuracy, validity, relevance, and verifiability of everything stated, claimed, and demanded in the affidavit. The degree of credibility of alleged statements, claims, and charges is established by the extent of the liability the accuser places at risk to be forfeited in the event that anything he or she states is untrue in accordance with the commercial maxim. Sacrifice is the measure of credibility. Negotiable. Negotiable means that which is capable of being transferred by assignment, a thing which may be transferred by sale and endorsement or delivery. Blacks first, of bills, securities, etc., transferable by delivery with or without endorsement. According to the circumstances, the title passes to the transferee. Webster's. Negotiable instrument. A writing which is signed by the maker or drawer, contains an unconditional promise or order to pay a sum certain in money, is payable on demand or at a definite time, and is payable to order or to bearer. Barron's third. A. Except as provided in subdivision C and D, negotiable instrument means an unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in the promise or order if it is all of the following. 1. It is payable to bearer or to order at the time it is issued or first comes into possession of a holder. 2. Is payable on demand or at a definite time. 3. Does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money, but the promise or order may contain 1. An undertaking of power to give, maintain, or protect collateral to secure payment. 2. An authorization or power to the holder to confess judgment or realize on or dispose of collateral. Or 3. A waiver of the benefit of any law intended for the advantage or protection of an obligor. B. Instrument means a negotiable instrument. C. An order that meets all the requirements of subdivision A except paragraph 1 and otherwise falls with the definition of check in subdivision F is a negotiable instrument and a check. D. A promise or order other than a check is not an instrument if at the time it is issued or first comes into possession of a holder, it contains a conspicuous statement, however expressed to the effect that the promise or order is not negotiable or is not an instrument governed by this division. UCC 3104. A negotiable instrument is a written promise or request for the payment of a certain sum of money to order or to bearer, a general name for bills, notes, checks, transferable bonds or coupons, letters of credit, and other negotiable written securities. Blacks first. See note. New debtor. New debtor means a person that becomes bound as debtor under subdivision D of section 9203 by a security agreement previously entered into by another person. UCC 9102A 56. Nobility. An order of men in several countries to whom privileges are granted at the expense of the rest of the people. Bouvier 6. 1. Persons of social or political preeminence, usually derived by inheritance or from the sovereign. Blacks 7th. The Constitution of the United States provides that no state shall grant any title of nobility, and no person can become a citizen of the United States until he has renounced all titles of nobility. The Federalists, number 84, from Bouvier 6, 1856. Note, judges and attorneys hold a British title of nobility from the crown and act as esquires or shield bearers for and between the king and queen and those whom the king and queen wishes to engage in battle. Nom, using expressions denoting a pseudonym, a false or assumed name. That's from Oxford English Dictionary, see nom de guerre. Nom de guerre, a fictitious name. Webster's National Dictionary of the English Language, unabridged, 1976. War name, a name assumed by or a name assigned to a person engaged in some action or enterprise. See note, compare nom. Note, any fictitious name is a war name or nom de guerre. The U.S. government, formally at war with you since the Amendatory Act of March 9, 1933, to the Trading with the Enemy Act of October 6, 1917, use the legal fiction artifice of the right to presume on your behalf and assign you a false name or war name in the form of your all capital letters straw man name, non de guerre trade name. See legal fiction. Non-negotiable. Not negotiable, not capable of passing title or property by endorsement and delivery. Blacks first. Any document of title that is not a negotiable document. An instrument which may not be transferred by endorsement and delivery or by delivery alone, though it may be assigned. Blacks 6. See note, negotiable. Note, the word non-negotiable appearing on one might otherwise look like a negotiable instrument signifies that 1. The contract is not negotiable and strictly private. 2. Both between drawer and drawee and obligor and obligee only. And 3. The debtor payee may pass title transfer the document neither by delivery nor by endorsement, but only through assignment. See drawee, preferred stock. Non-prosecutor. Latin, he does not follow up or pursue. If in the proceedings in an action at law, the plaintiff neglects any of those steps which he ought to take within the time prescribed by the practice of the court for that purpose, the defendant may enter judgment of non-pros against him, whereby it is adjudged that the plaintiff does not follow up, non-prosecutor, his suit as he ought to do, and therefore the defendant ought to have judgment against him. Under current rules, practice such failure would result in a dismissal of the action or in a default judgment for defendant. That's the Federal Rules of Civil Procedure, 4155. Blacks 6, C note. Note, when any plaintiff fails to respond as required under the principle of non-prosecutor, the defendant may enter judgment for dismissal for plaintiff's failure in following up as he or she should. Notary public, a public officer whose function is to attest and certify by his hand and official seal certain classes of documents in order to give them credit and authenticity in foreign jurisdictions, to take acknowledgments of deeds and other conveyances and certify the same, and to perform certain official acts, chiefly in commercial matters such as the protesting of notes and bills, the noting of foreign drafts and marine protests in cases of loss or damage. Blacks first, an officer appointed by the executive or other appointing power under the laws of different states. Their duties are generally prescribed by such laws, the most usual of which are 1. To attest deeds, agreements, and other instruments in order to give them authenticity. 2. To protest notes, bills of exchange, and the like. And 3. To certify copies of agreements and other instruments. Bouvier 6. Notaries are of very ancient origin. They were well known among the Romans and exist in every state of Europe, and particularly on the continent. Bouvier 6. Their acts have long been respected by the custom of merchants and by the courts of all nations. Bouvier 6. Note, notaries public are officers of the state, and in some state, notaries may become officers of the court as well. The seal of a notary gives a document credit and authenticity in foreign jurisdictions. In other words, international jurisdiction, hence the apostille. See apostille. A notary public performs certain official acts, chiefly in commercial matters. Commerce is prejudicial and non-judicial. Notaries public once played a major role in world commerce and still retain the same powers, though many have fallen out of use since America began using private, non-substance, fiat by decree money or Federal Reserve notes. Note, a writing acknowledging a debt and promising payment for the instrument to be negotiable, it must be signed by the maker and contain an unconditional promise to pay a sum certain in money on demand or at a definite time to order or to bearer. A note is not payment, but only a promise to pay. The term note is synonymous with promissory note. The term may be qualified, but it's unique by its unique characteristics. For example, a note that is backed by a pledge of collateral, such as real or personal property, is called a secured note. Barron's third. Oath, an affirmation of truth of a statement which renders one willfully asserting untrue statements punishable for perjury. An outward pledge by the person taking it that his attestation or promise is made under an immediate sense of responsibility to God, a solemn appeal to the supreme being, and attestation of the truth of some statement. Blacks fifth. Obligation, not defined in the UCC. Obligee, one who is entitled to receive a sum of money or to have an act or deed performed as promised or agreed to by the obligor. Barron's third. Compare obligor. Obligor means a person that, with respect to an obligation secured by security interest in or an agricultural lien on the collateral. 1. Owes payment or other performance of the obligation. 2. Has provided property other than the collateral to secure payment or other performance of the obligation. Or 3. Is otherwise accountable in whole or in part for payment or other performance of the obligation. The term does not include issuers or nominated persons under a letter of credit. UCC 9102A59. One who has promised or is otherwise obligated to perform an act or deed, such as the payment of a sum of money under a promissory note or other contract. Barron's third, compare obligee. Offer, a proposal to do a thing, a proposal to make a contract, also an attempt. Black's first. Order, in a general sense, a mandate, precept, a command or direction authoritatively given, a rule or regulation. In practice, every direction of a court or judge made or entered in writing and not included in a judgment is denominated an order. An application for an order is a motion. An order is also an informal bill of exchange. It is further a designation to whom a bill of exchange or negotiable promissory note is to be paid. Blacks first. See note. Note. None of the above definitions are incompatible with each other as regards the courtroom setting. The order of the court is pecuniary mandate for funds and is directly related with charges. In this sense, it is not dissimilar with a money order. Organization. Organization includes a corporation, government, or governmental subdivision or agency, business, trust, partnership, or association, two or more persons having a joint or common interest, or any other legal or commercial entity. UCC 120128, see note. Note, the term applies when two or more persons are involved in a specific commercial contractual relationship, as well as with any other entity involved in commerce. All individuals, in other words, all strawman trade names fall under the definition of organization. Order. Order means a written instruction to pay money signed by the person given the instruction. The instruction may be addressed to any person, including the person given the instruction, or to one or more persons jointly or in the alternative, but not in succession. An authorization to pay is not an order unless the person authorized to pay is also instructed to pay. UCC 31036. Original debtor. Original debtor, except as used in subdivision C of section 9310, means a person that, as debtor, entered into a security agreement to which a new debtor has become bound under subdivision D of section 9203. UCC 9102A60. Party. Party means a party to an instrument. UCC 3103A. Passport. In international law, a document issued to a neutral merchant vessel by her own government during the progress of a war and to be carried on the voyage, containing a sufficient description of the vessel, master, voyage, and cargo to evidence her nationality and protect her against the cruises of the belligerent powers. This paper is otherwise called a pass, sea pass, sea letter, or sea brief, a license or safe conduct issued during the progress of a war, authorizing a person to remove himself or his effects from the territory of one of the belligerent nations to another country, or to travel from country to country without arrest or detention on account of the war. Blacks first. In most countries of continental Europe, passports are given to travelers. These are intended to protect them on their journey, to protect them from all molestation while they are obedient to the laws. The Secretary of State may issue or cause to be issued in foreign countries by such diplomatic or consular officers of the United States and under such rules as the President may prescribe. Passports, but only to citizens of the United States. Bouvier's eighth. See vessel. Note, a passport is issued to a vessel, in other words, citizen of the United States. Trade names in times of war. The U.S. government officially declared war on all citizens of the United States persons in the Mandatory Act of March 9th, 1933, aka Emergency Banking Relief Act, to the Trading with the Enemy Act of October 6, 1917. See monopoly. Executive order outlawing ownership of gold in appendix, in other words, under executive order of the President, issued April 5th, 1933. Pay, to discharge a debt by tender of payment due, to deliver to a creditor the value of a debt, either in money or in goods for his acceptance. UCC 2511. UCC 3604. Blacks 6. See payment, redemption. Payee, in mercantile law, the person in whose favor a bill of exchange, promissory note, or check is made or drawn. The person or to whose order a bill, note, or check is made payable. Blacks first. See note. Payment, the fulfillment of a promise or the performance of an agreement, a discharge of an obligation or debt. In a more restricted legal sense, payment is the performance of a duty, promise, or obligation, or discharge of a debt or a liability by the delivery of money or other value by a debtor to a creditor, where the money or other valuable thing is tendered and accepted as distinguishing debt or obligation in whole or in part. Also, the money or other thing so delivered. UCC 2511 and UCC 3604, Black 6, redemption. Payment intangible. Payment intangible means a general intangible under which the account debtor's principal obligation is a monetary obligation. UCC 9102, 861. Pecuniary, of or relating to money. Monetary, Black 7th. Peonage, the condition of a peon, formerly a debtor kept in virtual servitude until he had worked out his debt, or the system of employing this form of labor. Perfect, or perfect, to legally establish. Security interest in collateral is perfected when a document describing the collateral is entered into the records of the UCC office. Compare attach. Perfection of security interest. In secure transactions law, the process whereby a security interest is protected as far as the law permits against competing claims to the collateral, which usually requires a secure party to give notice of the interest as by filing in a government office. Example given, in Office of Secretary of State. Perfection of a security interest deals with those steps legally required to give a secured party interest in subject property against debtors, creditors. Black 6. A security interest is perfected when it has attached and when all the applicable steps required for perfection have been taken. Such steps are specified in sections 9302, 9304, 9305, and 9306. If such steps are taken before the security interest attaches, it is perfected at the time when it attaches. And that's UCC 9303, 1, C, attach. Person. Said to be compound of per, through or by, and sonus, sound, a Latin word signifying primarily a mask used by actors on the stage. Persons are divided by law into natural and artificial. Natural persons are such as the God of nature formed us. Artificial persons are such as are created and devised by human laws for the purposes of society and government, which are called corporations or bodies politics. Blacks first. Persons are of two kinds, natural and artificial. In law, a human being is called a natural person. Artificial persons include a collection, corporation aggregate, or succession of natural persons, successive office holders in a corporation sole, forming a corporation. Blacks fourth. In law, an individual or incorporated group having certain legal rights and responsibilities. This has been held to include foreign and domestic corporations. Precise definition and delineation of the term has been necessary for purposes of ascertaining those to whom the 14th Amendment to the U.S. Constitution affords its protections, since that amendment expressly applies to persons. Barron's third, compare natural persons. See Uniform Negotiable Instruments Law, subsection 191, Uniform Sales Act, subsection 71, and Uniform Warehouse Receipts Act, subsection 58. See note. Note, the trade name is a person, a mask for the sentient living being who uses it. The trade name is a fictitious person whose name is written in legalese. In other words, a language foreign constructed outside the bounds of English grammar. The true names of men and women written properly, in other words, initial letters only capitalized, are sometimes called natural persons. However, it is just as impossible for a person to be natural as it is for a man to be artificial. Person is a moniker hatched by lawyers, introduced for generating confusion in the mind of the non-esquire victims between the actual and the artificial. See strawman. And at this particular time, we're going to stop right here. I advise you people to like, share, and subscribe. People, please like, share, and subscribe. Yes, people, like, share, and subscribe. Like, share, and subscribe. Be peaceful, stay blessed, and pray to pass God's test. And I will talk with you guys later.